Okay. Mr. Speaker.
I call the Honourable Minister Ian Tolley.
Mr. Speaker, I thank my colleague. I rise to speak briefly to the Parliamentary Privilege Bill, and I think listening to the debate so far and the collegiality that we see in the House, even in the order of speakers, is proof that it actually was an extraordinary privilege to come together in that committee and talk about issues that have nothing to do with the day-to-day politics that we're all consumed with on a daily basis here, but you know, to be able to delve into quite critical issues for democracy. And at times, I have to admit, as a non-lawyer, it was very esoteric discussion. But actually there were two very clear issues that we were addressing. One was the relationship between Parliament and justice and the courts, and that's of course defined as the comity. But that was actually around a decision made in the courts about how officials, how ministers and MPs can get advice from officials, and what protections there are for the performance of politicians to be able to rely on free and frank advice from their officials. And the second issue, again, related to the ability of ministers and MPs to speak freely in this House, both of which need to be protected under parliamentary privilege and have a long history. And of course, as a lover of history, that fascinated me. Even though we think we're modern in the 21st century, actually much of what we discussed goes right back to 1600s and the Glorious Revolution, which was to overthrow the Stuarts. And of course that's all tied up in religion, but politics is at the heart of it. And so we went right back to that Bill of Rights that was passed on the 16th of December 1989. And that restated in statutory form the Declaration of Right that was presented by the Convention Parliament to William and Mary, inviting them to become the joint sovereigns of England. And it laid down the limits of the powers of the Crown and set out the rights of Parliament and the rules then for freedom of speech. So when you dig right down into what was a very simple matter that went to court about the ability of an official to give a minister free and frank advice without fear of being taken to court for that advice, it goes right back to William and Mary and the Bill of Rights. And when you look at the Bill of Rights, it laid out certain basic rights. And the first was that there could be no royal interference with the law. And although the sovereign remained at the head of justice, they could not unilaterally establish new courts or act as a judge. The other one that was the other provision that was of note for us, well, the other two. One is there no royal interference in the election of members of Parliament, but secondly, the freedom of speech and debates or proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. And that went to the heart of the second issue that we were dealing with. So MPs are able to stand in the House and ask questions, to hold the government to account, make statements, and be able to do so without fear of court action against them, so that they had the right under parliamentary privilege to say in the House, always taking into account that we have a huge responsibility not to abuse that privilege, but to be able to stand by those statements that we made in Parliament without the fear of being taken to court. And so those two particular issues, one being able to get free and frank advice and from officials, and secondly, protect that right to stand in the House and ask questions, make comments, make statements without fear of the courts, was about the balance between the rights of and privileges of parliamentarians versus the rights and privileges of the court. And the balance, we felt, in the end was wrong, and this bill then attempts to put back in place those privileges that we deem to have been granted to parliamentarians dating right back to 1689 in the new dating. So it was a long and interesting discussion. I agree with the previous speakers that we were much well led by the Attorney General and David Parker, but I think in the end all members were able to contribute to what turned out to be a most interesting parliamentary bill. They had a number of changes. We were extremely well served by the staff, and the recommendations that we have made, I think, are of importance for all parliamentarians, because that does restore the rights that we all assumed that we had, and better protects the privileges that we hold dear in our New Zealand democracy. So, Mr. Speaker, it is a privilege to stand in the House and speak to the second reading of this bill, and I recommend the bill to the House.
Mr. Speaker.
I call the honourable member Grant